Judicial Officer before Judicial Officer Maha al-Mehairi and is being held by way of teleconference. The claimant is represented by HFW. Lead counsel is Stephen Doherty, assisted by Thomas Neighbour. The defendant is represented by Ashish Mehta and Associates. Lead counsel is Ashish Mehta, assisted by Mr. Nag.
Good morning.
Good morning.
Good morning.
Good morning.
If the claimant would like to start.
Yes, ma'am. Thank you. Before I start, can I check that you've managed to receive the bundle and check what you've had the opportunity to read?
Yes, I've received the bundle. I went through it, but I'm happy if the parties would like to elaborate.
Certainly. Well, I suppose first of all, by way of background and a summary of the case, I represent the claimant in this matter, Aegis, which is a company dealing in the supply and transportation of raw materials, primarily for the steel industry. Aegis had a banking relationship with the defendant, UBI, going back to 2017, and it set up a facility arrangement also in 2017. During May 2019, the claimant's email systems were hacked by an unauthorized third party who got access to the email account of its authorized signatory, Mr. Girish Agarwal. And between the 30th of May and the 10th of June, there were 4 fraudulent payment requests sent from Mr. Agarwal to UBI. Broadly speaking, those payment requests were for payments requested by 2 payees and banks that were based in Singapore and Mexico. And the payments were stated to be for mining operations and for mining tools. Of those 4 requests, 2 of the payments were transmitted to the requesting banks, so it was a sum of just over $1 million. The third request was stopped for a lack of funds, and then the 4th ultimately was picked up and stopped by UBI as a consequence of it appearing to be suspicious activity. Put very succinctly, and you'll have seen the detail to which this has been pleaded by the parties, the allegations raised by Aegis are a lack of due diligence and other failures by UBI in processing the transactions. In legal terms, it boils down to alleged breaches of UBI's contractual obligations, its tortious duties under the law of obligations, as well as regulatory and statutory duties it had as an authorised entity with the DFSA. The failures relied on are broadly the same under each of those heads, which is, and again put succinctly, the failure by UBI to identify the suspicious features of the transaction, a failure to satisfy its due diligence requirements before making those payments, so conducting its usual checks and processes, and its failure to follow a contractually agreed payment process that was in place and had been used in respect of other transactions. In respect of that, what the defendant says is that it didn't breach those obligations and acted in accordance with its legal and contractual duties. It further contends that it was protected by the existence of an exclusion clause in the contractual documentation, and it appears that it alleges that the claimant was contributorily negligent in relation to how it maintained its IT security. Now, the claimant seeks compensation in respect of the sums lost, so principally the $1 million and other associated damages. There is no counterclaim in this case. That's an overview of what the claim is about, and hopefully you will pick that up from the case memorandum submitted by the claimant. As to the procedural background, there was a deadline for submitting the memorandum and listed issues to the court. That was on the 21st of April. Now, the claimant sent its draft memorandum and listed issues to the defendant on the 13th of April in the hope that those would be agreed ahead of that deadline. We'll come to this in due course, but those were drafted in terms that the claimant considers was not controversial, fairly straightforward, and complied with the requirements in Part 26 of the rules of this court. And we also sent draft directions at the same time. Unfortunately, there was no response to that until the 20th of April, which was the day before the deadline for submitting. So as you'll have no doubt noted from the court file, there is no agreed case memorandum and there's no agreed list of issues. Fortunately, the proposed case directions submitted by the claimant have since been agreed, and you should have those draft directions in the bundle. But it seems as though the sole issue for this CMC relates to the list of issues which hasn't been agreed. And I'll come on to that in due course, but that's an overview of where we are and what this hearing is about.
Okay.
Ma'am, I don't know what the best way to go through this is. If the outcome of this hearing is intended to come with an agreed list of issues, I'm happy to go through those now and to refer you in the bundle, first of all, to where the claimant's list of issues are as a starting point for that.
Could we go through the list of issues that are disputed by the defendant or they have comments on, and then we can take it from there?
Yes, it seems as though a helpful starting point, first of all, might be to see whether there's anything in the claimant's list of issues which are disputed by the defendant.
Okay.
I'm not sure that that's necessarily the case, but those list of issues begin at page 105. I'm happy for the defendants to invite any comments there, and then perhaps after that it might assist to go through the defendant's proposed list of issues and the claimant's objections to those. Yes, madam, do you have page 105 of the bundle, the claimant's list of issues?
Yes.
Yes. Okay, so perhaps I think it assists to go through these one by one. The first list of issue put forward by the claimant, it doesn't appear to be in dispute, though I'm sure the defendant will confirm.
Just give us a second, we're just bringing it on screen.
Certainly. Madam, while that's being loaded by the defendant, I think it might assist the court and the parties to set out a brief reminder of the purpose and intention of these documents, so the memorandum and the list of issues. The provisions which are relevant are set out in part 26 of the rules of court, specifically rule 26.9, which provides that the memorandum should be a short and uncontroversial summary of what the case is about, and that the list of issues should be an agreed list of the important issues in the case. So it's not a recital of every single factual contention that might be set out in the pleadings, but it's to capture what the key legal issues are and the key factual issues. Importantly, the list of issues in the memorandum isn't, nor is it intended to be, an opportunity for the parties to restate the case set out in their pleadings at length. It's not an opportunity to put forward submissions on those pleadings or to advance or advocate for the position set out in those pleadings. It's not an opportunity to elaborate on or to further develop matters which are set out in the pleadings. And moreover, it's not an opportunity to materially amend what has been set out already in the parties' pleaded cases, because of course that would require an amendment. As a broad overview, we would suggest the claimant's memorandum, which I can take you to after if it would assist, but particularly the list of issues put forward by the claimant is compliant with those rules. First of all, the memorandum is set out in neutral and uncontroversial terms, setting out the respective position of the parties, but without seeking to advocate the position of either. And the list of issues are those important issues arising from the pleadings. So they set out what the aspects of the claimant's case that it needs to prove are, and it incorporates the matters which were raised by the defendant in its defence. If an issue hasn't appeared in the list of issues which we're going to go through now, the reason for that is because it's a contention that isn't an important issue that's central to the case. It may be that there are other factual issues that are of a more minor nature that will be dealt with in evidence in due course, but they're not for the list of issues in this instance. Or the other reason they don't appear is because the contention hasn't been pleaded, at least not in a way that was sufficiently clear in order to include it in a list of issues. And so what we would suggest is that the list of issues that we have put together is a uncontroversial starting point for what the court needs to determine. Now, I don't know if the defendant also has the page reference at 105. Mr. Mehta, can I check, have you got the page reference at 105?
Yes, we have.
Okay. Going through then the claimant's list of issues. First of all, it appears to be the case from the pleadings, from the particulars of the claim and the defence, that the defendant accepts that it was an authorised firm in the DIFC, and that as part of that, it had a licence to carry out specific activities, and as a consequence, it's subject to the requirements of the DIFC and DFSA's regulatory provisions, and that includes the conduct of business modules, general modules and glossary modules of the DFSA rulebook. Hopefully that point should be uncontroversial, and it appears to have been accepted in the defence, though no doubt the defendant will confirm whether or not that's the case. It follows from that issue 2 relates to some of the specific provisions of those regulations that the claimant relies on, and which is whether the principle set out in General Module 4 of the DFSA Handbook, and specifically Principle 2 and Principle 9, applied to the defendant in carrying out the business it was authorised to carry out. So those are agreed issues. The issue number 3 turns on to the duties of the defendant under the law of obligations. And again, this is a point that the defendant may clarify, because it may well be the case that this is not in dispute. But in the absence of an express admission or denial, I've left the issue in anyway, which is, did the defendant owe the claimant a duty of care under the law of obligations? And specifically, it then sets out what the test is under the law of obligations. It seems to me that that may well come out as an issue. It doesn't seem to be particularly controversial that a bank acting for its customer would owe a duty of care. There may be arguments about what the scope of that duty is, in which case those can go into the issues, but unless the defendant has any objections, that issue could come out. Well, assuming there's no comment at that stage, the next issue, again, should be relatively uncontroversial about the scope of the defendant's contractual obligations. So there's no dispute that there was a contract between the claimant and the defendant, which contained a number of material implied terms. Now, this is something which has been thrown into a degree of doubt by the defendant's case memorandum and list of issues. In its defence, the defendant appears to accept that the implied terms relied on by the claimant applied to it, and specifically we can see that at paragraph 95 of the defence, and I'll take you to that document to make that point. So the defence begins at page 30 of the bundle.
Just give us a moment.
And paragraph 95 can be found at page 63.
I'm just looking for it.
Could you just let me know when you have that page reference? I'd be very grateful.
Yes, we have.
And can I check whether the judicial officer also has the page reference?
Yes.
Yes. So at paragraph 95 of the defence, it follows a number of other submissions made in relation to implied terms, but what it says is that the implied terms relied upon by the claimant put no additional obligations on the defendant. Now, what that appears to suggest is that having already pleaded what the regulatory duties are under the general module of the DFSA handbook and the tortious obligations under the law of obligations, what the defendant is saying here is that the implied terms in the contract don't extend any further than those duties which already exist. And it seems to be therefore an admission that it did have, that those implied terms were a part of the contract. So if one turns then back to the list of issues at page 106,
Okay.
what appears in the claimant's list of issues is that it's not disputed there was a contract between the claimant and defendant which contained the following material implied terms, which then recites the implied terms which were set out in the particulars of claim. So again, we say that that's a point which has been admitted by the defendant, is not an issue in dispute, and so it's been confirmed that it's admitted in those list of issues. In addition to that, there are a number of live issues that can be disclosed from the particulars of claim in the defence in relation to other contractual terms. Specifically, those are set out at issue number 5, which is whether further to those implied terms, did the contractual documents which govern the credit facility contain other express or implied terms. We can see 5.1 relates to a specific term that the credit facility could only be used to finance specific transactions in relation to JSW Steel, which is something which has been set out by both parties in their pleadings. There's a term that the credit facility was restricted so that it could only be used to finance transactions in particular jurisdictions. Again, that's something arising from the contractual documents and which was referred to in the claimant's reply. And finally, that there's a term that the claimant was required to provide Dun & Bradstreet reports to the defendant for all transactions over a particular value. And again, that's something which is raised by the pleadings. And there's a difference between the parties as to what the correct terms are. So those have been identified as issues that are not agreed. Moving on to issue 6, this identifies what the claimant's specific allegations are in respect of breaches of duty. And I don't need to go through those, I don't think, unless it would assist in great detail, but they're set out in 13 points, which are points that are pleaded in the particulars of claim and which are denied in the defence. So of course those are live issues which the court is going to need to determine. And then having answered any of those questions, either affirmatively or in the negative, the court will need to go to question 7, which is whether taken separately or cumulatively, did those failures constitute a breach of any of the duties pleaded by the claimant. So breaches of the DIFC regulatory law, breaches of the DIFC law of obligations, or a breach of the defendant's contractual obligations. So again, we say that sets out in very clear terms what the important issues in the claimant's pleaded case is, and those issues which have been specifically denied by the defendant and which the claimant is going to be required to prove at trial. The next section of the list of issues then turns to some of the matters pleaded specifically by the defendant in its defence. And the first issue at 8 is one of the core aspects of that defence, which is was there a letter of indemnity which formed part of the facility agreement or other contractual terms relating to the credit facility? In other words, were there terms which meant that the scope of the defendant's contractual or tortious obligations were narrowed so that it could process payments purely off the back of receiving an email from the authorized signatory? And if such a term did exist, first of all, whether the manner in which the term was pleaded was sufficient to exclude its liability, that's issue 9.1. Secondly, whether that term was reasonable under the DIFC's implied and unfair terms law, and therefore whether it was valid, or otherwise whether the term was valid taking into account the provisions of the conduct of business module of the DFSA rulebook, which is stated in the list of issues and was pleaded by the claimant. And then the other issue, aside from indemnity, which is raised by the defendant's pleaded defence, is whether the claimant's own negligence led, at least in part, if not all, to all of its loss. So that's an argument in contributory negligence, and of course that would only relate to any claim under Article 17 of the Law of Obligations rather than relating to any claim under contract or under the regulatory provisions. And then finally, arising from those core issues comes the issue of causation and loss. So but for any of the aforementioned breaches, would the fraudulent payment requests that were made have been refused or otherwise blocked by the defendant? Or alternatively, if the defendant has found to have breached any of those duties, would it, had it not breached it, made the claimant aware of the attempted fraud such that it would have stopped the payment requests itself? And then the final specific issues are in relation to the losses claimed. So is the claimant, based on those findings, entitled to compensation of just over $1 million and then associated losses, including bank charges, consequential losses, and expenses incurred in seeking to recover the sums, and interest. So when we say that those are an uncontroversial list of issues, I'm sure you'll hear from the defendant as to whether or not they agree to those list of issues. But in any event, those are the issues that were sent to the defendant on the 13th of April, and which were not substantively engaged with. And what the defendant chose to do was to produce its own separate list of issues, wouldn't agree with the statement of issues that had already been provided, and have led to us attending this hearing today in order to iron out these issues because they couldn't be agreed. Now, I don't know whether you wish to hear from the defendant on whether it has any objections at all to the claimant's list of issues before I move on to addressing the defendant's list of issues. But we consider that the primary reason that we're having this hearing is in order to deal with the defendant's list of issues.
Does the defendant have any comments on the claimant's issues?
We do have objections to the list of issues raised by the claimant, and we would address them from what we have submitted as defendant's list of issues.
Okay.
Could we start?
Yes.
Yeah, you'll allow me to. I've got a bit of a short.
I don't know if we're going to say, if we're going to turn to the defendant's list of issues, I'm happy to, so that we can deal with everything in one go. I can address what our objections are to those list of issues so that the defendant can then pick up and have any comments that it has on what we are inviting the court to find.
Okay.
So it might make sense for me to give you those submissions rather than the defendant going through its own list for the moment.
Okay.
Okay, the list of issues that were submitted by the defendant, so the case memorandum begins at page, so bear with me, page 125.
Yes.
And the list of issues is at 124.
So the case memorandum actually begins at page 125 of the case bundle, and the list of issues.
Sorry, 133. Apologies.
133.
Correct.
Okay.
Thank you. Madam, the overall thrust of the submissions we have to make about this are that, as I said at the outset, the list of issues isn't an opportunity for the parties to restate or set out their case, which is already set out in the pleadings. It's not there to put forward submissions to advance those arguments or elaborate on them, or to add issues that haven't been raised already in the pleadings. It's supposed to be a sober, neutral statement of what the issues are to assist the court in reaching its determination. Now, there are, I suppose, one or two aspects of the fresh list of issues submitted by the defendant which are live issues, but insofar as they are, those are issues which have already been identified by the claimant in its list of issues, which was submitted for the agreement of the parties.
Excuse me. We would like to go through the defendant list of issues, if you don't mind.
Okay, let's hear their comments and then you could go through the list of issues.
Okay, thank you.
Now, we would say it's plainly obvious from even a glance at this list of issues that it doesn't comply with the material provisions of Part 26. And so, for example, if we start on the first page, we have section 1.1, which sets out what it says is the context. Now, if one looks at what the content of that is, and this is an issue, I should say, appears again and again in this list of issues, but what this section does is advocate the defendant's position. It refers to what the claimant's contention is, and then it says that the second paragraph, however, it is to be noted that the first payment requests were all sent from the authorized email address of the claimant's authorized signatory. Reference may be made to contractual provisions, and then it makes its point about what those provisions say in order to contend for its view of what the contract says. Now, whilst that sort of statement might quite handily appear in a skeleton argument or in submissions, or it might be a point that's made in oral submissions, it's not something that should be appearing in a list of issues which Part 26 provides the parties should be agreeing. This isn't a statement to advocate your case. When you actually look at what's in the context, when you remove those elements of advocacy, essentially the issues are about, first of all, and we can see these at 1.2 when we look at the specific issues themselves. But issue 1 is about what the contractually agreed payment process is, which is disputed between the parties. That is an issue which has already been addressed in the claimant's listed issues. It's at 6.11. But 1 and 2 really are getting at the question of whether there are contractual indemnities that allow the defendant to avoid any liability if its payment request came from an authorized email address. Now, that question of the indemnity is already covered by issues 7 and 8, which I've already taken you to in the claimant's listed issues. So, in terms of substantive issues in the case, some of them can be ascertained from section 1 of the defendant's issues, but those issues were already dealt with and should simply have been agreed when the claimant included it in its own list. Question 3, whether the defendant is liable to determine the authenticity of a payment request sent to it from the authorized email address. Again, that is similarly covered by the indemnity question at 7 and 8 of the claimant's list of issues, but also by one of the specific breaches identified in issue 6 of the claimant's list, which identifies the specific due diligence failings of the defendant. So again, 1, 2, and 3 materially repeat something that already appears in the claimant's list of issues. Now, it's question 4 of this first issue, which particularly raises eyebrows and deserves separate consideration, and that's whether the claimant is in breach of terms of the facility agreement and the letter of indemnity. Now, this is the first of many examples of why it's simply not possible for the claimant to have agreed to any of the matters raised in the defendant's list of issues. This is a claim brought by Aegis against UBI for contractual breaches and breaches of its regulatory and tortious duties. It's unclear how or why an alleged breach by the claimant of the terms of the facility agreement could be relevant to those issues, but aside from that, the defendant isn't pursuing a counterclaim in this litigation. It is not saying that there was an alleged breach of contract by the claimant that entitles it to some form of remedy. And moreover, the defendant hasn't particularized any way in which it says the claimant has breached the terms of the contract. It hasn't identified what the terms that it says were breached were. It hasn't identified how it says those were breached or what the significance of any such breach to this litigation is. And since that hasn't been pleaded, the defendant can't use this list of issues to significantly amend or replead its case. I mean, it may well be that this is how cases are pleaded in the local courts, but that's not how one litigates in the DIFC. So far as I'm aware, at no point has the defendant sought consent to amend its pleadings. And since issue 4 isn't part of the defence, unless the defence is amended and unless it includes a counterclaim, put simply, it is not an issue in these proceedings. Moving on to issue 2, we can see more of the same thing. So the context section, again, we can see that it repeats lengthy submissions and parts of the pleadings. This time it actually refers to case law in support. And again, this is advocating the defendant's case. It might well be part of the skeleton argument, but not this list of issues. Importantly, it also seems to suggest that there are certain facts which have been agreed. So, for example, if we look at page 135, and it's the second main paragraph beginning with following the terms of the facility agreement, the letter of indemnity. The claimant accepted that the defendant could accept payment request received from the authorized email address and provided such payment request contained the signature of the claimant's authorized signatory. Well, that's not the case. That's not agreed between the parties. It's suggested that it is. It's actually one of the central issues in dispute in the case, but the defendant hasn't framed it like that. Importantly, what's set out here from a legal perspective isn't clearly defined, whether here or in the pleadings. So the issue which this context section appears to be getting at is, what was the contractual payment process in place between the parties? 2, was there an indemnity? And 3, if there was an indemnity, was it valid under the implied terms law? Now, those are all issues that have been raised and addressed in the claimant's list of issues. What is unclear is why the defendant is referring to Article 55 and Article 59 of the Law of Obligations. It is not enough for the defendant to rely on an issue simply to set out a provision of law without explaining why that provision of law is relevant to the dispute and why, therefore, it is an issue in dispute between the parties. So, although we have referenced Article 55 of the Law of Obligations, which relates to the assumption of risk, what the defendant doesn't say is what risk it says was assumed. For example, is it saying that in entering into a banking relationship with the claimant, the claimant assumed a risk that payments might be made to fraudulent third parties? That seems like it would be an unduly wide assumption of risk for a bank to assert. But if that is what's being alleged, then it's not been pleaded. And if it hasn't been pleaded properly, on the face of it, that aspect of the defendant's claim lacks merit, particularly where it's already accepted that it has certain due diligence obligations. Moreover, in relation to Article 55, it doesn't say how the claimant was aware or knew of the risk that is said to have been posed but decided to proceed anyway. And in any event, it appears to be a misguided submission, because the issue here isn't about an assumption of risk. It appears to be a dispute about what the scope of the defendant's duty was in relation to carrying out due diligence, both as a matter of contract and a matter of tort. And if that is what the defendant is alleging, then that's already covered by issue 3 of the claimant's list of issues. So with that in mind, when we look at what the issues are set out, so 2.2 on page 135, whether the claimant has made a voluntary assumption of risk under Article 55, and then issue 2, whether there was an exclusion of the defendant's liability. Well, the first of those hasn't been properly pleaded and can't therefore appear in a list of issues. If it is a live issue between the parties, what the defendant needs to do is to apply to amend its defence. And in relation to issue 2, it's already been covered by the issues identified by the claimant, which relate to the exclusion clause and whether or not it is a valid exclusion clause. Moving on to issue 3, which relates to the implied terms law. We can see that, again, we reiterate the same criticisms again, unfortunately, in relation to the context section of 3.1. What it does is set out at length what the legal provisions are, largely copied over from what's in the defence. And we see reference over on page 128, in the middle of the page, to case law, and 3 points which the defendant makes about that case law, which again we say is clearly a matter for legal submissions. It's for the parties to argue before the court in due course what the proper interpretation of the law is. It's not something that should be contained in the list of issues, and the rules are very, very clear about that. But in any event, it's unclear how the law itself, so Article 40 of the Implied Terms Law and Schedule 2 to that law, are actually relevant or disputed issues in the case. Of course, the claimant accepts that the provisions of the Implied Terms Law apply to this case. In fact, it relies upon them. It's unclear why at 3.2 of its list of issues, so page 138, the defendant has decided that each provision of Schedule 2 should be a separate and distinct issue before the court. Ma'am, no doubt you're aware that the reasonableness test in the Implied Terms Law is not about the application of an exhausted list of factors. It's open-ended. The question of reasonableness is something to be assessed by reference to all of the facts of the case. What the court doesn't need to do is go through an exercise of applying each and every provision set out in Schedule 2 to ask whether or not that applies. It may be something that it will do in due course when it's considering this matter by way of party submissions, but they're not specific or important issues to be included in a list of issues. So under 3.2, the first set of questions 1 to 5 are not issues and they need to be taken out. But perhaps the most important part is in relation to further issue 1, which asks whether the defendant may be held liable under the Implied Terms Law, even if it had duly complied with all of its due diligence requirements. Now, not only do we say that is that not a disputed issue between the parties, but is also not capable of being a disputed issue between the parties. There is no question before the court that says that the defendant is liable under the Implied Terms Law, even if it complied with its contractual obligations. The entire reason for referring to the Implied Terms Law is part of the court's determination of what the express and implied terms under the contract are. So there's not some freestanding liability under Article 40 which would give rise to liability on the part of the defendant, notwithstanding what the other contract are. That's not a properly put case. What the implied terms law deals with are about when provisions are unfair, and it sets a reasonableness test for that. So the question is, was there an express or an implied term as contended for by the claimant? And if so, was that, sorry, it's not that, it's whether there was a express or implied term which was an exclusion clause included by the defendant in the terms of contract, and if there was it reasonable? That's the question. It's not about some separate liability. And that question is covered by the claimant's list of issues. So in that regard, we say that the entire of Section 3, first of all, isn't properly pleaded, but second of all, doesn't appear to identify any issues which are in dispute between the party and therefore needs to come out. Moving on to the latter part of the list of issues, and I know that a number of criticisms have been levelled already, but sections 2 and 3 of the defendant's list of issues are perhaps some of the more egregious examples of the extent to which the defendant has failed to comply with the provisions of Part 26 of the Rules of Court. Part 2 relates to an alleged obligation on the part of the claimant to protect its email systems. Again, we can see the context section beginning at the bottom of page 138 and continuing into 139 reiterates some contentions in its pleadings. But importantly, and I refer specifically to the second paragraph of the context section, it adds elements that are not contained anywhere at all in the defence. These are completely new allegations. It's unclear what the relevance is said to be, but it appears to relate to what, in general, security should be provided by service providers. That is the first time that an allegation of that sort has appeared anywhere in these proceedings. It has no place in a list of issues because it is not part of either party's pleaded case at all. The context section continues, beginning with the paragraph, the claim brought by the claimant is based on the premise that it's been a victim of online fraud. However, it didn't provide access to its systems to determine the exact reason for the occurrence of the fraud. Well, again, there are a number of issues with that. The first is a query as to what the relevance of that is in any event. But perhaps more importantly, if the defendant wants to make submissions about the investigations that took place and the extent to which the claimant took part in them, whilst I'm not going to address the court on the merits of that part of the defendant's case, but really what that is a submission on the weight that should be given to particular types of evidence. It's not actually an issue in dispute that the court needs to decide. It's something that can be dealt with in closing submissions, and it has no place here. Moreover, it's unclear why the defendant has sought to include this anyway, because the defendant says in its list of issues that it disputes the contention that the claimant has actually been a victim of fraud. Well, on that point, it has been admitted, or it should be taken to have been admitted, that that is the case already. So, for example, in the defence, there is no specific denial that the claimant was a victim of fraud. In order for there to be a denial and for a pleading to be compliant with the provisions of Part 17 of the Rules of Court, and specifically Rule 17.27, if a denial is going to be made by a party, it needs to give a reason for doing so. The defendant has at no point in its defence suggested that the claimant was anything other than a victim of fraud, and it has sought to defend this case for other reasons. It can't therefore be included as an issue in these proceedings now when it hasn't been pleaded. So looking at the issues themselves, beginning at 2.1, and again, this is without getting into the merits of the allegation that's being raised here, but what the defendant says is an issue is whether the claimant has a duty to protect its email systems against cyber attacks. Well, the defence doesn't plead that the claimant had any legal duty to protect its email systems. If it does purport to allege that it hasn't done so properly, for example, it doesn't identify what kind of duty is this. Is this a duty under the law of obligations? Is it a contractual duty? Is it some other kind of duty? If there was a duty to protect the email systems, who was that duty owed to? Because it seems that in effect what the defendant must be saying is that the claimant owed a duty to itself. If there was some kind of duty in relation to IT systems, what was the scope of that duty? What would have been required for the claimant to have complied with that duty, and how does the defendant say that that was breached? And in any event, even if you answer all of those questions, what could the possible significance of that duty be? Because there is no counterclaim. The defendant is not saying that a duty owed to it by the claimant was breached, and it is therefore bringing a claim for damages. None of this is pleaded, and as such, it has no place in the list of issues. So question 1, again, should be struck out of the list. Question 2 is whether the claimant failed to protect its email systems. Again, the defendant hasn't pleaded any basis in which it says that the claimant did fail to do so. It doesn't say what standard of protection should have been provided, and if the defendant wants to rely on that argument, it would need to amend its pleadings to specify how it says that the claimant failed to protect its systems so that the claimant could properly respond to that part of the case. Question 3, as I say, whether the claimant is actually a victim of cyber fraud. This has already been admitted in the defence, and there is no positive pleaded case advanced by the defendant, which is compliant with Part 17, that otherwise denies that the claimant was a victim of fraud. And question 4 is worth dwelling on, and perhaps a little longer, because it is perhaps one of the most egregious examples of the attempts by the defendants to use the list of issues to muddy the waters of what is relevant and what is not in this case. And so what issue 4 says is whether the claim be allowed to subsist even as the investigation in respect of the transactions could not be completed to ascertain the source of the payment requests in question. A number of points about that. First, it is, to put it generously, unclear what is being asked for in question 4. Is it, for example, seeking to stay proceedings? Is it seeking to discontinue proceedings? Is it seeking to strike them out? If that was the case for any of those points, certainly there is no identified legal basis in which the court could act upon issue number 4. Certainly there is no application in relation to any of those matters, or indeed any application before the court. But perhaps more importantly, the matters identified by the defendant here are not relevant to proceedings. The claimant isn't under any duty to wait until the defendant finishes its own investigations before it brings a claim, and certainly it has no obligation to take part in those investigations, particularly where it has a reasonable basis to suspect that ultimately what the bank is doing is fishing for a reason to avoid liability, and that is a suspicion which we say is reasonably supported by the defendant's pleaded case and supported by this list of issues, which is in effect trying to throw everything at the court in the hope that something sticks. So none of the issues set out in this section are issues in proceedings. And these egregious examples, we say, continues into section 3, which is at the bottom of page 139, and continuing into page 140. First of all, I'd make the point that the fact that the defendant has included pleas for relief by the court highlights the extent to which the defendant has misunderstood the entire purpose of the case memorandum and the list of issues by seeking to put a request for relief in them. That is particularly surprising given that there is no pleaded counterclaim, and the defendant has expressly said in its case memorandum that it is not pursuing a counterclaim. Nevertheless, what the defendant is asking the court to determine in these proceedings, for example, if we look at question 3 in this issue, is whether the claimant is liable to pay damages to the defendant. Well, put very, very simply and in plain terms, that of course cannot be part of the issues of these proceedings. This is a claim brought by the claimant against the defendant, there is no counterclaim, there is no allegation of any breach by the claimant of any legal obligation to the defendant, and there is no sustainable claim for damages whatsoever. It's symptomatic of the entire approach that the defendant has had to putting together its memorandum and list of issues. What the claimant would say by way of overview is that not only are the issues identified either already covered by the claimant or simply not relevant, but they highlight that the defendant has missed the point completely. They have sought to advocate their case in presenting a list of issues to the claimant. They were sent a day before the deadline for submitting those issues, and they were never going to be capable of being agreed. And put very, very simply, the document produced by the defendant is not useful to the court in determining what the issues are in this case. And we would invite the court to accept that the issues to be determined are those already identified by the claimant. I think those are the only points I need to make for now. It may be that there are some issues I'll address in rebuttal, depending on what the defendant has to say.
Okay, thank you for your submissions. Mr. Ashish?
Yes, please.
Okay.
Yeah, I have, Ved will be addressing most of these. I've got a very sore throat, so I don't want to hurt it further. But okay, we'll start now.
All right. So we've been listening to Mr. Stephen, and we have noted a few points without wasting much time of the court or the CMC discussion. We'd just like to submit by saying that the case memorandum that was initially sent to us was partially done, and it was lacking in a lot of facts. So a lot of facts were actually left out from the case memorandum that was submitted to us. Essentially, in para 2 of the case memorandum, which is page number 99 and 100. Well, case summary, that would be page number 100, para 6. So now here, the claimant had mentioned that it has been having a current account with UBI as well as a credit facility since June 2017. However, the defendant has records to show that Aegis Resources DMCC has been having an account, a current account with UBI since February 2017. The account opening form was signed on 9th February 2017, and then a transaction was also made of about USD 600,000. Along with the account opening form, a letter of indemnity was also signed by Mr. Girish Agarwal. The letter of indemnity, we are privy to it, and the bank has the originals with Mr. Girish Agarwal's signature and Aegis Resources DMCC stamp on it. We have already submitted this as an evidence, Exhibit C2, along with the defense that was submitted long before. The letter of indemnity essentially has points wherein the bank is indemnified, the bank, which is the defendant, is indemnified by the claimant on transactions for which payment requests were sent electronically. Electronically would mean facsimile transactions and email transactions. So here in point number 2, without taking much time of the court, the bank is under no obligation to identify the party giving the instructions. So the only issue in this regard was that the claimant was actually trying to subvert and disregard the 2 essential documents which were signed at the time of account opening. These were the account opening form and the letter of indemnity. 6.1, 6.2, 6.3, 6.4, they essentially list out the documents which were relating to the credit facility. However, they disregarded the documents which were essential to the account opening form. It is also disregarded by the claimant that facilities cannot be granted simply without opening an account. So all the documents which were relating to account opening are also very material to this case, and they have to be referred by the court. Without going through the contents of them, issues cannot be determined. And any issues determined with incomplete facts will actually be cause for more worry, and then it will cause the parties to engage the resources and time of the court unnecessarily at a later stage. So this part is totally disregarded. It has been mentioned before in the defense as well that the account was operating since February 2017. Facilities were then sanctioned in June 2017. Meanwhile, transactions were also happening. Then the claimant has, in its submissions in the case memorandum, it has only repeated what has been stated in the particulars of claim, that email systems were hacked, unauthorized third parties gained access to the email account of Mr. Girish Agarwal, the authorized bank signatory for Aegis. However, it is disregarded that this email address, which is mentioned admin@aegis-overseas.com, this was the registered email address for the banks to look into and to comply with all payment requests which came through this email address. However, this part is not really taken into consideration in the case memorandum that was sent by the claimant. Further, it is also disregarded that it was a common ground between the parties that Aegis would be sending payment requests to UPI from the registered email address, and it is also to be considered that all the payment requests which are in question in this case have come actually from the registered email address, which is the email address of Mr. Girish Agarwal mentioned in page 100 and para 7. Now, a lot of questions have been raised regarding why we are asserting now that the defendant is disputing whether the claimant authorized email address was actually hacked or not. Well, it could not be ascertained. Neither the claimant has supported its contention by providing any evidence in this regard. Later on, the claimant had actually approached the defendant regarding claiming insurance costs for the supposed breach of security or the hack that had happened. However, it could not be ascertained. The defendant had on its part been cooperative, and it was trying to ascertain the reasons for which these transactions had taken place. However, the claimant was not supportive of this, and in this regard, the defendant was sending correspondence to the claimant, but the claimant did not respond to them. In this regard, it is also essential to mention that at least 3 investigating teams were deputed around November and December of 2019. The first one was from Dubai Police. The second one was from New India Assurance Corporation Limited of India, which was the insurer of the defendant. And the defendant, this was in regards to the insurance claim which was supposed to be made. And the bank, which is the defendant, being a professional bank, had on its part also engaged a separate investigating team voluntarily to ascertain the reasons for the breach, supposedly. However, even after communications being sent, the claimant did not respond to them. So it was a material fact, and that's why it has been made part of the case memorandum, and later on list of issues were also drafted accordingly. We noted that the draft memorandum that was sent by the claimant was not uncontroversial exactly, and controversies were there, and those could not be agreed upon.
Madam, apologies for interjecting at this stage. just to raise a couple of points. The first is in relation to the most recent submission, which is if there were controversial parts in the claimant's case memorandum, those haven't been identified. It's unclear how any of those any of the matters set out in there could be deemed to be controversial. But perhaps more importantly than that, I note that what we're on the verge of doing is going through an exercise to discuss the substance of the case. Now, the precise reason that we are here and the basis on which the claimant has already made its submissions is that the defendant has fundamentally misunderstood the purpose of the CMC, the purpose of the case memorandum, and the purpose of the list of issues. So the CMC is not a forum to litigate the case. We'll have our opportunity to have our say at the merits hearing. This is to deal with administrative issues, not to point out each and every factual assertion made by the parties in their pleadings, which obviously stand in their own merits. The case memorandum doesn't have an impact on what the issues are in the case. It is not used by the court at the merits hearing, and so that is why it is supposed to be a short and uncontroversial summary of what the parties' cases are, and that the list of issues is supposed to identify the important issues in the case. These are here to assist the court, and I'm conscious that we're already occupying some of the court's time, but I'd be reluctant to go down a path where we are reiterating the parties' substantive cases when that is not the purpose of this hearing. And in fact, that is the very point that the claimant has sought to make at this CMC.
Agreed. Mr. Ashish, please go through the list of issues and please do not discuss the merits of the case.
That's what our intention is. We were just addressing the reason why we had to give our comments to the draft case memorandum, which we had agreed, because we found material facts were not represented. Some factual information was incorrect, such as the account opening date is incorrect. It is not June 2017, it is February 2017. Now we will address the list of issues.
Okay, we'll start from page 105 of the list of issues, the claimant's list of issues, and then we'll counter that with our list of issues, and we'll also specify the reasons for which we had raised those issues in the list of issues that we presented. Now, the duties, defendant's duties under the DIFC regulatory law. Well, the defendant is a professional bank in the DIFC, and it is subject to DIFC regulatory law. So there has not been a dispute in this. The next line of issues which are raised by the claimant are the defendant's duties under the DIFC law of obligations. Now, it is correct that we had mentioned this in our defense. However, we failed to notice that the contentions which were raised in the defense were not were actually raised in the list of issues which were submitted by the claimant. So this was essential for us to bring out in a fresh list of issues that we presented eventually. Now, the claimant had raised DIFC law of obligations being applicable on the defendant. However, the claimant failed to ascertain the reasons for doing so, and basically the law of obligations, I'll just go to our list of issues. So why this is essential. Yeah. Now, law of obligations and the obligations relating thereto cannot be just imposed on the defendant without understanding the full context of all the provisions in the law of obligations. So if the claimant is trying to impose obligations on the defendant, so it must also be noted that Article 55 of the law of obligations provides an exception where it says that whether if there was a voluntary assumption of risk, and that's why we quoted Article 55 of the law of obligations. Then Article 59 of the Law of Obligations also needed reference. Article 59 relates to exclusion of liability. Further, because this is a common law jurisdiction, we have to rely on a case law. That's why Raiffeisen Central Bank Osteridge AG versus the Royal Bank of Scotland PLC was cited. So now Mr. Stevens said that he doesn't understand the context in which the issues were raised in this. However, he did not consider the last paragraph before clause 2.2 here. We have said specifically that it is therefore the defendant's contention that the claimant is agreeing to the terms of the facility agreement and the letter of indemnity, and that the claimant, in agreeing to these documents, had made a voluntary assumption of risk. Further, the defendant was also excluded from any liability while acting in accordance with the contractual terms. Now, we cannot be expanding every paragraph and going back to reiterating all the provisions once again and again. The reference to facility agreement in this regard was made in context of clause 18.3 of page 134, which says that the lender shall have no liability to any party hereto in respect of any loss suffered by the reason of the lender acting in accordance with any request for instructions set out in an email or fax sent to it. Mr. Stevens said that whether the claimant was assuming a risk by simply entering into a banking relationship. No, we are not referring to that. The risk in this case is the consequences of sending payment requests via email. Now, this email address, the authorized email address, is mentioned in clause 18 of the facility agreement. This has been submitted as an exhibit already. And this is why the law of obligations is incomplete without mention of Article 55 and Article 59. So, in essence, it was the defendant considered that these two also needed due consideration in the list of issues. Because without considering these issues, it cannot, the law of obligations and the obligations coming therefrom cannot be imposed on the defendant. Because essentially the claim that has been brought forth in this case against the defendant is based on whether the defendant was actually lacking in its obligations or had not fulfilled its obligations duly. So in this case, we have also to consider the defenses that are provided in the law of obligations. Without going through them, we cannot really just consider the obligations that were there. Next in the list of issues raised by the claimant, we are going to the list of issues. So contractual obligations. We have raised the contractual points that were there. One are the contents of the letter of indemnity, and then there are provisions from the facility agreement. Now, it is not disputed that there was a contract between the claimant and defendant which contained the following material implied terms: that the defendant would act with due care and due diligence, generally in and about the performance of the contract and in providing its services to the claimant as a banking institution. That the then 4.2 says that the defendant would take reasonable steps to safeguard the claimant's accounts and to prevent misuse of the accounts by third parties. 4.3 says the defendant would review payment instruction requests provided by the claimant to ensure they had actually been made by the claimant. 4.4 that the defendant would verify transactions with the claimant in accordance with the processes agreed upon by them. The defendant had actually complied with all these requirements. The defendant's breach of its duties or contractual obligations. Now, they are raising the issues in respect of the first, second, and third fraudulent payment request. Did the defendant fail to identify the request, copied email addresses that were unconnected with the claimant, failed to identify that the fraudulent payment request had no apparent connection with JSW Steel and were outside the terms of the utilization of credit facilities, failed to identify the invoice provided in respect of the fraudulent payment requests, and a number of other such failures which they are trying to impose on the defendant. However, this is incomplete if we do not consider the other provisions of the implied terms law. That's why we have included all these implied terms provisions in the list of issues that we submitted. Without going into the details, I think this should suffice. Now, claimant's obligation to protect its email system. The defendant considered that protection of the email systems was very essential because in the particulars of claim and later on in the reply to defense, the claimant has repeatedly mentioned that if the defendant was a bit more careful, and basically the claimant has been speaking from a position of saying that the defendant had an obligation to identify the fraud which was committed on the email account of the claimant. The claimant at no point assumes any sort of liability. The defendant had on its part a duty to accept payment requests and make transactions after that. The payment request, it came from the authorized email address. The payment request contained the signature of the authorized signatory of the claimant. So these two essential requirements are there already in the facility agreement. So basically the defendant has not breached any of its obligations. It was just complying with its requirements as a banking organization, and it was acting in a bona fide way, accepting the payment request from received electronically from the authorized email ID. So in this set of circumstances, whether or not the claimant's obligations to protect its email system should be considered material to this case is the question the defendant wanted to include in the list of issues. And the next set of issues raised in the list are the defendant's pleas, which really follow from the defense, which was submitted before. And the defendant hoped that these pleas would have been considered and be made part of the list of issues which were submitted by the claimant. Now, in essence, the reason this CMC is taking place is because the claimant and the defendant could not have a consensus on the case memorandum relating to the facts that were submitted and the list of issues that were submitted. Now, in a lot of places, Mr. Stephen has been saying that we have really not understood the context in which the CMC is being conducted, and that we had a responsibility to have an uncontroversial case memorandum and list of issues. But given the circumstances, there was the defendant was left with no choice. The HFW as counsels for the claimant had actually sent documents to us on 13th April for our consideration. And if the intention was only to submit those documents in the form that they were sent to us, then why we do not understand the requirement of sending them to us for our comments. We could have just sent them a response saying that we do not agree, and they can we would like to submit the documents on our own while they submit on their own. Well, it is to be noted that the claimant's counsels have not accepted any of the suggestions, even if they were material to the case, and hence we had to come to this CMC discussion.
Mr. Ashish, let's move on to the defendant's case memorandum and list of issues.
Sure.
Yes, Ms. Alia.
Start with the defendants. Just bring it up on the screen. Give us 1 minute.
Yes, okay.
Please.
All right, so we will begin by submitting the points referred in the case memorandum, which was submitted by the defendant's case memorandum. So essentially, the claimant, Aegis Resources DMCC, is a company with limited liability incorporated under the laws of the Dubai Multi-Commodities Center, and the UBI is a DIFC-based bank. The claimant has been holding a current account with the defendant since February 2017. Subsequently, the claimant obtained credit facilities from the defendant in the form of letter of credit facility, trust receipt.
Mr. Ashish,
Yes, please.
we already read the document. I just want you to reply back to the claimant's issues so we could move on.
So you want us to respond to the claimant's list of issues? Or?
Yes. No, the claimant had issues, had comments on your list of issues. So
Yeah.
if you can reply back, and then we could conclude the CMC.
Sure.
Okay.
Yeah.
Ms. Alia, can we ask Mr. Stephen to again come back with the questions so we can answer them in turn?
Could you give a general reply back to the things that he said? I don't want to go through the questions that he had. We've already gone through it, and it's a waste of the court's time.
Okay, we shall do so.
All right, so we'll just make the submissions accordingly. Our submissions are as follows. The case memorandum have actually facts missing, and therefore the list of issues could not be determined based on missing facts. Account opening form was executed in the month of February in 2017 and not in June 2017. Then after that, a transaction had also happened for USD 600,000. These are material facts to the case. Then the claimant did not consider the email address of Aegis, which was registered with the defendant, and that the defendant was actually having the mandate to accept payment requests issued by Aegis on the registered email address. Further, the fraud could not be ascertained because the claimant did not provide any evidence till date, and also when repeated calls were made regarding investigations, the claimant did not respond to any of them. There were 3 instances in this regard. Now, Mr. Stephen had further mentioned that it should be an uncontroversial account of the facts. However, the case memorandum that was submitted did not have an uncontroversial account of the facts. It actually had a controversial, it was actually controversial on several contexts. The contexts have been specifically described in the defense previously and now in the case memorandum as well. We had also noted one thing, that we had submitted our comments on the case memorandum that was submitted to the court, but it was not made part of the case bundle. Regarding investigation, if we go to the defense, Mr. Stephen had said that no reference is made to investigations previously. We can go to the defense, and in para 102.8 of the defense, which is page number 65 of the case bundle. It was said that the defendant has undertaken for cyber forensic audit to find or determine errors, if any, in both transactions. However, the claimant did not support or provide access to its system for this audit. Due to such non-cooperation by the claimant, the defendant forensic audit findings could not be concluded. The defendant further submits that the police investigation is ongoing under the Dubai Police and Singapore Police. So we fail to understand why Mr. Stevens said that the defendant was never disputing the fact that disputing whether it was indeed a fraud conducted in respect of these transactions.
This issue was raised before, not just now, as counsel for the claimant had mentioned.
Further, in respect of amending pleadings, we'll take instructions from our client, the defendant, and will respond accordingly. Most of the issues that were raised by Mr. Stevens in the CMC have been addressed before in the defense, and we have submitted to them.
Okay, so if you don't have any further submissions, we can conclude the CMC.
We would
Madam,
like to say that the case memorandum draft which was sent to us had material facts missing. Some facts were stated incorrectly. Therefore, it was sent to us for our comments, not for our information. So when we corrected those facts by sending track mark document, it was not accepted by the claimant's counsel. As a result, we had a disagreement and we are having the CMC.
Okay.
Madam, I have some points in rebuttal to some of the matters that have been raised. I propose to deal with them fairly briefly and in the order they arose.
Okay.
By way of overview on the points I'm going to make, the defendant has now sought to explain its rationale for including certain matters in its list of issues and memorandum, but the reality of this is that none of this was pleaded, and it is not open to the parties to come along to the CMC and set out their case properly for the first time. I note the point that has just been made about we'll take instructions on amending our pleadings, and again we say that this is a further example of how the defendant has adopted an approach to this litigation which is not in accordance with the court's rules, and to put it very, very bluntly, isn't acceptable. And one of the places that we can see that is in the very last part of the list of issues that was submitted by the defendant. What it seems to suggest is that, well, we'll reserve our position to add further allegations and further arguments in due course. Well, you can't reserve your position in that way in proceedings before the DIFC courts. The pleadings in this case are closed. They have not pleaded these parts of their case, and it's not open to them to, as the directions for this case progress, to simply move the goalposts and change its case on a whim. The further point to raise really is that it's pretty clear from the defendant's actions there is no intention whatsoever of agreeing these documents ahead of the hearing, and it has used that process and this hearing to utilise what it's considered to be an opportunity to advance its case. Obviously, that is not the purpose of this hearing. Turning to some of the points they made on our issues, well, the first of one was issue 3, which related to the duty of care. What the defendant seems to have made clear is that it agrees with what we set out as the issues there. It accepts that there was a duty of care issue. it sought to lump on some points about Article 55, and it gave some of its rationale for doing so, but that rationale was not pleaded. And in fact, it's still not pleaded in a way that would be capable of the claimant responding to. So in relation to a case on assumption of risk, they have still failed to identify what the identified risk was. They failed to identify how the claimant was aware that that was a risk, and they've failed to identify how the claimant nevertheless is said to have assumed that risk. Insofar as it's about the consequences of having sent payment requests by email, again, that's not specifically pleaded, and what in effect is being relied on is a simple statement of what the relevant legal provisions are, and the defendant is clearly under the impression that it can just make it up as it goes along and add whatever allegations it wants later down the line, and then to rely on its vaguely pleaded defence in order to say that it had pleaded those parts of its case. On issue 4, which related to the implied terms that have been pleaded and relied on by the claimant, in our list of issues we said it is agreed that G's duties were owed. And the first thing that the defendant said in its comments on our draft was that the defendant complied with those requirements. It necessarily follows that they do in fact admit that they were contractual requirements and that they therefore do admit that those were implied terms. So again, I don't see why that issue could not have been agreed. On the point of email systems, the issue raised was that the claimant was said to not have assumed any sort of liability. Well, we reiterate the point we've already made, which is there's no counterclaim here, and the question of any liability on the part of the claimant is totally irrelevant to these proceedings. In the event that what's actually being alleged is, say, contributory negligence, well, first of all, it's not pleaded like that, and second of all, if an application was made to amend the defendant's case to include it as an allegation of contributory negligence, then that is already covered by the claimant's list of issues, which deals with that issue. In relation to the defendant's ongoing investigations and its not making any admission as to the fraud, it might be helpful to have a look at what the pleadings themselves say. So first of all, the particulars of claim, which starts at page 6, and I'll refer you to paragraph 28, which is at page 10 of the bundle. If you just let me know when you have that page reference, I'd be grateful.
Page what?
Page 10 of the bundle, the particulars of claim, paragraph 28.
Okay.
That is the claimant's pleading that it was subjected to fraud. So unbeknownst to the claimant, his systems were hacked by unauthorized users who gained access to the email account. Now, paragraph 28 of the particulars of claim is responded to at paragraph 25 of the defence. So the defence begins at page 30 of the bundle. And paragraph 25 is at page 37.
Okay.
And I'm happy for you to take as long as you need to read it, but what the defendant is saying here is, in its response to paragraph 28, which is the allegation that a fraud was committed, it says that the defendant holds no liability for the hacking of the authorized email address, and it's supported by the fact that it wasn't in control of the claimant systems, that they had agreed to act on payment instructions, and that there was a letter of indemnity. And then says that's just as the claimant was oblivious of its own email address getting hacked, the defendant has no means or obligations to know this. Now, what's important to note there is that there is no express denial at all that the claimant was a victim of fraud. The way that that paragraph is defended is by reference to the indemnity, not by reference to the act itself. And I'd remind the court of what Rule 17.26 says about the contents of a defence, which is that the defendant must state which of the allegations that are denied, and 17.27, which says that where the defendant denies an allegation, he must state his reasons for doing so. In this case, there is no denial that a fraud took place. At best, there is a requirement that the claimant come up to proof on that. But there's no suggestion that what we have said in our list of issues is in any way incorrect. It's what arises from the pleadings. The defendant might subsequently look at that and say, oh, perhaps we should have denied that there was a fraud, but the fact is they didn't. They have not asserted any facts on which to base such a denial anyway, and on that basis, it's not an issue in these proceedings. As with every part of his case, the claimant obviously has to come up to proof, but that doesn't mean it goes into a list of issues. Turning to a couple of the other points that were made by the defendant, the defendant seems to criticise the claimant for the way it sent the documents on the 13th of April. It says that we've not accepted any of their suggestions. Well, there are a number of obvious points to make about that. The first is, for the extensive reasons we've already given, either the issues raised by the defendant were already on our list of issues, but in any event, they left it one day before the filing deadline to send us what was an extensive fresh memorandum and fresh list of issues that completely failed to adhere to the provisions of Part 26 of the rules of this court, and it would have been impossible to reach an agreement in a day given the fundamental flaws in those documents. It's clear that the defendant had no intention of agreeing those. First of all, because we say it wouldn't even agree to our uncontroversial memorandum in a very simple and straightforward list of issues. The defendant has repeatedly said that there were some incorrect assertions in our list of issues, but it's failed to identify any of those, or certainly to identify how they might have been material. I mean, so far as this is just a dispute about whether or not the banking relationship started in June or in February that year. Well, first of all, the comments in our memorandum related to the facility agreements, not to the opening of the banking relationship. But in any event, if that was a problem that they had, all they needed to do was say, you got the date wrong. It was February, not June. That could have been agreed, put into the memorandum and submitted. But that isn't the approach that the defendant adopted. Similarly, it would have been perfectly simple for the defendant to take the list of issues that have been identified by the claimant, and if it had minor comments or minor issues that it thought had been missed, it was open to them to put them in. What they have instead decided to do is to extensively replead their case, to include references to case law, to advocate their position, to include submissions, and to include things that frankly have never been raised before, as well as a counterclaim that doesn't exist and a request for some form of unspecified relief that the court should stop these proceedings. Now, those documents of themselves would have been impossible to agree even if we'd been given 2 weeks or 1 week or anything other than a day. So we say that the court should conclude that the defendant had absolutely no intention to agree that list on that basis. What we say overall is that the documents prepared by the defendant are not fit for purpose, and that the only way that this case can be properly progressed at proportionate cost and with a view on what the central issues are actually in dispute between the parties as framed by their pleadings is that the court should adopt the list of issues that the claimant has produced, and that those can be used to inform the procedural steps going forward. Because the last thing the court wants is to continue to allow the defendant to shift the goalpost of its defence and to submit a pile of witness evidence, of documentary evidence that doesn't go anywhere near the central issues in dispute between the parties. By agreeing to our list of issues, it ensures that the court will keep a handle on what this case is about and ensure that the parties are taking reasonable and proportionate steps to advance that case with the directions that have been agreed between the parties.
Conclude, may I add something here?
I think we heard enough from both parties. If there isn't any...
In the merits of the case, please, if you will permit me.
In relation to what?
In relation to the draft case memorandum, we have given our comments. It's not that we are not shifting any goalpost. We had shown intentions to an agreed order for direction with the claimant, We don't want to delay proceedings. We don't want to incur additional cost. If we had to, we could not even agree to order for directions. Thank you.
Okay, thank you.
Madam, I could add before we conclude these proceedings that whatever orders are made is the claimant's intention to apply for certain costs incurred as a consequence of this hearing, but I can address you on those submissions after.
I saw your documents in relation to costs. The court will review both documents and will revert back by email. In the situation that costs are awarded, you will be notified by email.
Yes, madam. In that case, may I make the submissions that I have on costs? Partly they follow what I've already said, so I can skip over those parts. But to put it very, very...
To determine that, let's leave it up to the court to decide on that.
Well, the court will decide, but the court ought to hear from the claimant in relation to its application, particularly in relation to clarifying what costs are actually claimed, which is an issue that I haven't addressed.
Okay, Mr. Stefan, but very briefly.
Yes, the main point to note is that the cost schedule served, it's not the entirety of the claimant's costs for this hearing. The claimant accepts that there would have been some exchange of correspondence. The claimant would have had to prepare the case memorandum and list of issues anyway, and that some work would have had to go into the CMC in the normal course. What we say is that the cost of the CMC hearing itself, and for certain of the steps taken after the 20th of April, which is when the defendant sent its fresh list of issues and fresh case memorandum, that those costs could have been avoided. The directions in this matter were agreed between the parties, albeit after some attempts to get the defendant to engage with those directions. And the hearing really has only gone ahead to deal with a list of issues which we say ought to have been agreed and which the defendant has made impossible for the parties to reach agreement, as we say, by including matters that weren't pleaded, by putting forward its submissions, and by identifying issues which were far too late in the day to agree. So the schedule of costs that you look at there is only in relation to the work that has gone into preparing responses to those lists of issues and into preparing for this hearing. As I say, it's clear that the defendant had no intention to agree this and left the parties in a situation where this hearing was unavoidable. Had the defendant engaged more meaningfully and had it sought to engage with the spirit of the court's rules, this hearing could have been avoided and probably ought to have been avoided, and the parties could have progressed the claim in line with the directions that were agreed and in line with a sensible list of issues.
So, Mr. Stephen, are you expecting me to accept your draft case memorandum without giving my comments? We gave you our comments. You didn't accept those comments, which were very valid information missing from it. So we have not compelled you to come for a CMC. You were not willing to take our comments into consideration.
Madam, I think you already have my submissions on that, so I don't think you need to hear any more on why it is we say that
let's leave it for the court to determine it.
Okay, thank you both for your submissions. The court will take into consideration your submissions and will revert to you by email.
Thank you so much. Have a nice day.
Thank you.
Thank you.
Thank you.
Thank you.